Hello, bonjour. Hello to all, dear friends, dear colleagues. So happy to be able to see you in flesh and bones, finally. We were mentioning that earlier. Hopefully we won't, we are not losing our social skills at social gathering. We'll see later, but I don't think so. So I would like to welcome you to this midterm conference of the ACT partnership. This partnership relies on your precious collaboration, so I would like to thank you for coming in such large numbers for these 3 days of conference, which are going to be very rich and fun, hopefully. It's a pleasure to welcome you in person after a pandemic that we hope is now behind us. As you know, our first keynote speaker will not be Daniel Boursier, a pioneer in the field of AI and law, who for health reasons cannot be with us today. She has, however, graciously agreed to record her speech that we'll include in the recorded version of the conference that should be available on our platforms during the month of October. We've tried to fill in for Danielle, but the time frame was very tight, and some colleagues suggested an online speech, which did not fit with our idea of an in-person gathering. So a key tenet of the ACT project and the Cyberjustice Lab has always been educating students and informing them of the challenges posed by the networking of judicial actors and the use of AI in the justice sector, among other things. So these students are, I believe, the future of cyberjustice. Ne sont-ils pas le sel de la terre? One such student is Hannes Westermann, whom we met at the hackathon held as part of our 2017 summer school. Hannes won the hackathon and did join the lab. It was at that time that the Cyberjustice Lab team began to think about a computer tool using AI that could simplify public access to legal information. This questioning led to the creation of this collaborative project that we now call the JusticeBot. Hannes has supervised, with the help of Marc Lichten, a fantastic team composed today of Jie, Sébastien, Aurore, Tan, Sylvain, Olivier, Mia, Frédéric, Jules, Rémi, and many others who have contributed to this project. Therefore, I have decided with my colleagues, my team leaders, to ask the students working on the JusticeBot project at the lab to present the keynote this year. As you may know, their work has already led to the deployment of the first JusticeBot dedicated to housing dispute, which has been accessed over 12,000 times since July 2021. But this keynote is about the future, and the future is them. So the students will present their vision of the future, for the future, I mean, of the JusticeBot project, including expanding it into new legal fields beyond housing dispute and developing the platform capabilities with one central objective in mind, always, facilitate access to law and justice. Make it easier for everyone to exercise their rights and be an informed citizen. I think that this will be a very good and dynamic introduction to our conference. And after the conference, we'll meet in the Salon François Chevrette for another drink, to which you are formally invited right after this introduction, and you will be able to ask questions and exchange with the JusticeBot team. They will, of course, join us. I will turn the floor to Hannes, who will present you the JusticeBot project. Thank you, Hannes.
Thank you very much for this introduction and the invitation to present our work here today. It's really good to see all of you here in person once again. But we also know there's a cocktail after, so we won't take too much of your time. I'm Hannes Westermann. I'm the lead researcher of the JusticeBot project and the PhD candidate here at Université de Montréal. And we're here together with our team to talk about JusticeBot perspectives for the future. So we have a big agenda. I will start with a brief introduction, talking about the present of the project, but then we'll go on to the future to see what other paths there might be of expanding this. So we'll hear from Tan about other application areas. We'll hear from Sébastien about going from lay language to legal language. We'll hear from Aurore on a project about automatic summarization. We'll hear from Jie about JusticeBot and ODR. And then I'll wrap up and talk a bit about some research projects that are even further out beyond the horizon. So, to introduce, I want to talk to you about the JusticeBot project, which is very much a child of the ACT project. I still remember standing over there 5 years ago at the inaugural meeting of the ACT project, pitching the project to all of you. And of course, since then, a lot has happened, both in the ACT project and the JusticeBot project. So we thought this would be a great moment to look forward, to not look at what we've done, but what we are hoping to accomplish in the coming years in the scope of the project. So what then is the project? And I'll be very brief here since I know many of you have already seen this. But the project really started with the idea of access to justice, that there is many people who do not have access to a way of resolving their disputes and knowing their rights, especially in vulnerable communities. So what we're hoping with the JusticeBot project was a way to improve this situation. And the way this works is that we have built a platform and a tool that asks questions to the user to understand their legal situation. And each question has here a title, but also a simplified explanation telling them what this means, and also examples from case law that summarize this deliberation. And then we analyze their situation, and we give them information that can help them understand their rights in those situations. And we also give them possible next steps, what they can do to enforce their rights or to improve their situation. We think this is something that could be really powerful and is really powerful to empower self-represented litigants, since they might not know how the laws apply to them and what the laws are, but using a system like this, they can understand this better for their own case and know how to proceed better to enforce their rights. And the first version of this, the first implemented JusticeBot, is the JusticeBot TAL, which is focused on landlord-tenant disputes. And we launched this last summer in July 2021 together with the Tribunal Administratif Logement, which is the court responsible for such disputes, and also together with Aide Juridique Montréal et Laval and with financing from the Ministère de l'Économie et l'Innovation in Quebec. And we're quite happy with how it's been doing. Over the first year, there were about 12,000 users that accessed the platform. And even more importantly, about 86% of people answer that they would recommend this platform to their friends. And getting the feedback of these users has been a very important part of this process, to try to understand how they use it and how we can further improve the platform. And a really important aspect here is not just the implemented tool, but also the platform behind it, how we built this JusticeBot. Because JusticeBot isn't just this one tool, but it's also a platform behind it. So this platform allows people to construct these kind of tools, JusticeBots, in many different legal areas. And to do this, it's really an end-to-end tool chain. So you can go from an idea to encoding the legal rules and the case law to arriving at a finished project, all inside this platform. And we built the JusticeCreator, which is the front-end interface for this. So it allows you to very easily, with a drag-and-drop interface, create these new pathways, connect them together logically, and also add case law. And it has some AI features in there that find cases that could be relevant and allow you to include these in the platform. And this is something that we've been using together with a team of legal experts. So we've seen that it doesn't really need computer skills to use this, to build this JusticeBot. And we think that's a really powerful feature to expand the scope of this and to implement it in many new areas. So that's what we had for now. But now, today, we want to look towards the future. And we'll hear from our team about many exciting projects on the works. We'll hear from Tan about applying this kind of project to other legal areas, the JusticeCreator platform. We'll hear from Sébastien about making the front end easier to use. We'll hear from Aurore about making the creation of the pathways more efficient. And we'll hear from Jie about expanding the capabilities of the platform, all connected to this core that we have built until now. And then I'll come back and talk briefly about some beyond the horizon projects that are a bit further off, but also really exciting. So those words, I'll pass the word over to Tan, who'll talk about other legal areas for the JusticeBot.
Great. Thank you, Hannes, for your introduction. I'm Tan, a research assistant at the Cyberjustice Laboratory and a PhD student at the University of Montréal. Today, I will present the potential contribution of JusticeBot in other legal fields. Let's start with a real-life case. Recently, Mary faced a bedbug problem in her apartment, and she told her landlord, but the landlord didn't give any response and help to her. And she would like to know what rights she have under the law, what she should do, and how other people facing similar problem were dealing with it. Of course, in front of Mary, there are three options. First, consulting a professional lawyer to get an opinion. Second, use search engines such as Google to get relevant information about how to solve a bedbug problem. Of course, third, Mary can use our JusticeBot platform. Let's start with option A, consulting a lawyer. As we all know, consulting a lawyer is really expensive and time-consuming, which obviously is not the best choice to solve a bedbug problem. And in the past, a search engine like Google is the best option for people who are facing problem as Mary to find relevant information. But in Google search, users are required to describe their situation, and they need to find relevant information from the vast amount of information provided by Google, which is really difficult for layperson, especially in Google search result. There are many outdated information, irrelevant information, and misinformation. Different from the options before, JusticeBot use multi-choice questions to let users choose from. So users do not need to describe their situation. They just need to select the right option, matches their situation along the path. And then relevant information and the relevant judgments will be provided to the users. Problem solved. After actual simulation, we found out that JusticeBot is 2 times faster than traditional web search. Here is the simulation results above. As you can see, JusticeBot is at the bottom. It's really way more faster than traditional way. But we don't want to stop here. JusticeBot's excellent feature can go even further. In Google search, as you can see on this slide, left is Google search result, and the right side is information provided from JusticeBot. When users describe their situation on Google, and they can get thousands of similar blog posts to describe how to solve a bedbug problems. Some of the blogs are even longer than traditional law review articles, which scholars do not even have patience to read. Of course, it's really difficult for lay people to read. And this blog post will describe the definition of a bedbug, the origin of a bedbug, the typology of a bedbug, and then to the very end of the blog post, the users will be informed, maybe you can call your landlord to solve your bedbug problem, which is not Mary want. But in JusticeBot, we only provide relevant information without giving users excessive information that they will fall into the sea of the irrelevant information. As you can see, there are 3 catalog, and users can just follow those 3 instructions, and they can get the right information they want. And we are excited to expand this exciting new tools into other legal fields. JusticeCreator make it all possible. JusticeCreator is a reliable, distributive, fast, and convenient modeling system, which allows computer scientists and legal experts to work closely and efficiently on cross-disciplinary fields such as AI and law. And they can use their domain knowledge to build new paths together. Here is the blueprint of paths of future JusticeBot. As you can see, we are right now building consumer protection, data protection paths. Those fields contains a lot of potential users without what to do when their rights are being violated. So with JusticeBot in new field, we can provide users relevant information easier, and we can promote access to justice in the future. This is a demonstration of new passes. As you can see, we are trying very hard to build new passes and try to provide accurate and relevant information to users. And we cannot wait to share this exciting new future with you. And let's turn the floor to my colleague, Sébastien.
So, yes, you can hear me perfect. Thank you, Tan. So, I'm Sébastien Meeùs. I'm a PhD student at the University de Montréal in a joint degree with the Université Libre de Bruxelles. I am a research assistant at the Cyberjustice Laboratory and also head of the YouTube department. And today it's my turn to discuss an important aspect of JusticeBot development and how to improve the user journey. But first, let me convince you once more on the strength of JusticeBot. Because here at Benyekhlef Westermann, we strive for excellence when it comes to delivering the best product. So this is why we came with this first advertisement that I will tell you the story right now. So, it's Friday night. You are in a bar. It's been a long week at work. But now it's the time to cheer yourself up with a drink and a good company. Speaking of which, you see your friend approaching the table. But she seems upset, so you ask what's wrong. And in fact, she has a problem with her landlord. And even though you have many qualities, legal knowledge of housing issues is not one of them. It is no longer a problem because JusticeBot is here for you. JusticeBot, the answer to your legal questions. So we believe we did well, but we still wanted to improve the story. And by that, I mean how to improve the way users are interacting with JusticeBot. So we conduct surveys, feedback, and research, and that's where we found the room for improvement because laymen think of the situation in terms of facts rather than legal outcomes. So on a conceptual level, the idea was to add a layer of accessibility on a typical user journey, which consists of the starting point, a few choices along the way, and it ends with the information given by the tool. And the goal was to add checkpoints, bridges, and shortcuts, which means that the user will skip questions and go further away in their user journey. And that's the expected result. And the practical solution that we are currently fine-tuning is natural language processing suggestions. And as the name implies, we want to propose suggestions rather than choosing for the user. So we believe that he will be able to check if the suggestions are correct. And on a practical way, he will have less choices than the current starting point, which can be a bit long for a user. But now let me show you this with a demo that is as currently a test. But if you go here and then that's the current JusticeBot. But if you choose, like here you are a tenant, and here you have the current starting point, but up here you have, you can input something. So let's say that you feel like your flat is very cold, so you can just type that. And in this test version, you will get a few suggestions. And I tap that in French, and it's in English, and you show suggestion in French. But the idea is that the first one is really related to the issue with eating problems. And if you click, you will get further away in the user journey, and then you come back to the usual way with yes or no question. So this way, we believe that we expect that the user will be less misdirected during their user journey. and that's the solution we are still fine-tuning at the moment. But if you like Benyekhlef Westermann services, feel free to reach us during the cocktail, and we will be very happy to add you to our billable accounts. But first, let's continue the keynote with Aurore.
So thank you, Sébastien. Hello, everyone. My name is Aurore. I will present a work that that is still in progress, and we are working on the automatic summarization of legal court decision together with Olivier Salin and Sylvain Longuet. So my name is Aurore Troussel. I'm a researcher at the Cyberjustice Laboratory, and I'm also a PhD student at Université de Montréal. So why summarization? As you've seen on JusticeBot, the bot is asking legal questions to our users, but sometimes it's difficult to really understand how you can answer this question. So the idea is that we provide to the user some case to illustrate no answer or yes answer. But to help the lay people just to understand the legal decision, we provide both the link to the original and full text decision and a summary of those decisions. Those summaries so far are drafted by legal experts. So our goal is to solve a problem because we discovered that between reading a full text decision and a summary, the majority of people will prefer to read only the summary. So this is the case for more than 80% of our users. So we are trying to explore ways to summarize legal court decision. So here, globally, how it works, this is a transformer developed by Google, and just the input text is the full text, and the output text is a summary of this text, and there are different methods to summarize legal text. So at JusticeBot, we had to face with 4 main challenges. So first, the data acquisition, because as you might imagine, it's very costly to summarize legal court decision. We need to rely on legal experts, and also it's very time-consuming. The other challenge is that summarization is a very complex task. This is why it's one of the main challenges in natural language processing research now. And it's complex for human, even more for AI. Also, we are working on legal French court decision, which means that we cannot use most of the natural language processing tools that are available so far. Finally, we need to build really trustful models because we cannot provide a wrong or inaccurate summary of a legal court decision to lay people. So to face all of those challenges, we built a methodology, and we are using an original data set thanks to JusticeBot. So in our data set, we have the questions that are asked by JusticeBot, the different possibility of answer, the full text of related decision, as well as humanly drafted summaries. So far, we have 156 humanly drafted summaries, so it's a short data set, but still we can try to work on this. The model we are using is Barthez, so it's a model that is working on French language, and it's at the state of the art so far for natural language processing on French text. And so our methodology is to use as input text either question, answer, and full text decision, or other different combination of input text. For example, we also try to just give to the model a question, the full text decision with paragraph in the reverse order to see which combination is the best. So at the end, we had candidate summaries that we decided to evaluate. So we use first an automatic evaluation of those summaries relying on automatic metrics, the most common one. But what we've seen and what we've understood is that those kind of automatic evaluation allow us to know which combination has the best scores. However, it's not enough to really understand whether our summaries are useful for lay people and whether they are accurate. From this, we decided to create a human scheme to evaluate those summaries. So this scheme consists in first reading the full text decision, second reading the humanly drafted summary, Third, reading the candidate summary which has been generated by our model. And finally, for each of those summaries, we had to answer 7 questions related to both the form and the substance of the summaries, and to rate those summaries from 1 to 4. So we did this. We were only 3 evaluators, Sylvain, Olivier, and I, so 2 people with legal background and 1 NLP expert. So from our evaluation, it was really a first exploration, but we understood that the best models were the one with the more data as input. So when we inputted the question, the answer, the full text decision to the model, we had the better result. However, more importantly, we also discovered that the automatically generated summaries contain legal mistakes. So here in the first illustration, you can see that towards the period according to which the tenant can be considered as often late in payment was different from the automatically generated summaries than from the humanly drafted summary. This means that even if the format of the summary is correct, and even if the automatic evaluation could give a good rate to those automatically generated summary, in fact, it contains legal mistakes. The other illustration shows that, for example, in the interpretation of the law, the automatically generated summaries contain also mistakes. Here, for example, in the humanly drafted summary, we see that the notice is invalid because it's written in French while the contract is in English, while in the automatically generated summaries, even if the notice is written in French, it is lawful. So this is a big problem that we are working on now. But what is important to highlight so far is that we really understood that we need always to keep human in the loop when developing such model, to always assess the accuracy of the summaries that we are providing. So I would say that, to conclude, that our approach is quite original because we've seen that other researchers used, such as Kevin Ashley or Ken Sato, use extractive method to do legal text summarization, while here we tried to use abstractive summarization. Also, our input data are quite interesting because we are not just trying to summarize a legal decision, but we are also trying to answer a legal question. So this is also something that is quite new in our approach. We are also working on French legal court decision, and all our summaries are directed to lay people. So now this is a work in progress, and we are still developing better human skin evaluation in order to scale up a bit the evaluation of automatically generated summaries. And what I would like to highlight here as well is that this research is really a way to improve the access to justice for lay people, and we hope that our summaries, by using abstractive approach, will provide summaries without having too heavy legal vocabulary. Thank you. So I will give the floor to Jie.
Thank you, Aurore. So my name is Jie Zhu, Cyberjustice Lab Research Assistant and PhD candidate at the University of Montreal. So even though the world will stay the same, and perhaps on account precisely of the sameness, I'm pretty happy to be here, as most of you hopefully are. So let's gonna think about what we are gonna do next after we have diversified our many pathways, refined user experience, and our case summary capabilities. So our next step will be to evolve our JusticeBot into a functionally efficient online dispute resolution, or ODR, platform. As you are aware, ODR has become a mature technology that basically provides a digital space in which parties can convene and solve the disputes in a way alternative to conventional trials. And just as a brief summary of the history, the first ODR platforms, as you recall, had been developed by the private sector and as well non-profit research institutes, mainly for internet-related and e-commerce litigations. Then ODR technology has been annexed to a part of our public court system as well in an effort to streamline the court process, so as an alternative way of delivering public justice. But the story does not end there. We are seeing the rise of ODR-driven online tribunals, which no longer have dedicated physical premises, and some members of these virtual tribunals are with us in this audience, as I have just found out. And this is really exciting, and the evolution is in line with what many commentators have recognized for a while now. And the Supreme Court of Canada, in one of its landmark cases, mostly known for its reference to the shift in culture for our civil procedure, has acknowledged that the best forum for resolving a dispute will not always be that with the most painstaking procedure. And as Richard Susskind has been asking since the late 90s, we should instead think of justice as a public service rather than a place of gathering, so there is no inherent uneasiness to imagine or even require the online delivery of court services. Which drives us back to our JusticeBot. The benefit of having an ODR platform is that instead of providing legal information to one user at a time, we will bring together parties on both sides of the disputes and help prompt out-of-court settlements in appropriate cases. As you are acutely aware, access to justice has two intricate dimensions, and procedural fairness matters as much or even more than reaching a substantively fair outcomes. So what we are going to do first is to ease the way that justice is being administered at a procedural level, like by allowing parties to file their claims, defenses, and counterclaims on our platform, which would be connected to the relevant court registry. They can as well be kept up to date about upcoming court processes. They can plan negotiation sessions, initiate and respond to settlement proposals 24 hours a day, 7 days a week. And then on a more substantial level, some types of disputes lend themselves more conveniently to an algorithmic kind of analysis. And I'm thinking about low-intensity monetary disputes where the applicable law and the facts are relatively clear or uncontested. And we are targeting a subset of these categories of claims involving the award of general versus actual damages. The difference between the two, for our purposes, is that the award of actual damages does not depend on how prior cases fare, but whether you have the relevant evidentiary records, since they record actual computable losses. On the other hand, general damages, such as punitive, emotional, moral damages, the award of which does not depend on actual evidentiary records alone, and the award may be jurisdiction and even court-specific, and this is where AI-powered ODR comes in. So let's take an example of a claimant who, in addition to his actual damages, such as rent reduction, is suing his landlord for his emotional distress induced by the bedbug-infested apartments. So as you can see from this slide, there are initially a wide gap in expectation between the two parties. And in such situations, our ODR JusticeBot will go over the available evidentiary records and review relevant case laws so to come up with the range of amounts that our courts have awarded so far, all conditions being equal in similar cases. And based on this information, both parties will hopefully adjust their expectations and proposals within this range and hopefully settle. So to recap, the added value of an ODR JusticeBot is really its ability to process large quantity of legal data in a more efficient way and to convey the results in a user-adapted and easy-to-read manner. And to achieve this, we will require the help of all of you and a lasting collaboration between our JusticeBot team and public authorities, litigants, courts, and councils, and other stakeholders so that we may be kept up to date about our users' current need, as well as provide them with quality and up-to-date data. So on this promising note, Hannes will lead us to a world beyond the horizon.
Thank you, Jie. So I'm back again to talk about some research that is beyond the horizon. So we heard 4, I think, really interesting pitches here. There were pitches as we tried to change up the academic format of presentations a bit and make it more dynamic. So I hope they were able to sell you on these visions for the future of the JusticeBot. But, and we heard about applying the JusticeBot to new legal areas, like consumer rights and privacy, about making the front end easier to use by going from layman language to legal pathways, about making the creation of pathways more efficient by summarizing cases, and also on expanding the capabilities of the platform by integrating it into ODR. But now let's look beyond the horizon, that is at research that we are currently conducting, but that won't pay off for maybe a couple of years, but once it does, could be really interesting and exciting. And this research is based around the insight that the way we model pathways in the JusticeBot is actually quite close to how many jurists reason about cases. As you see here, for example, the JusticeBot works by connecting blocks logically together. The first here, for example, is the tenant frequently late with paying their rent? If the answer to that is yes, the next question would be, does the landlord suffer a serious prejudice due to this? And if that answer is also yes, both of these cumulative requirements have been fulfilled and the lease can potentially be terminated. Whereas if either of those answers are no, the lease will not be able to be terminated by a judge. And that information is then given at the end to the user of the JusticeBot so that they can proceed with this information. But this is modeled on the way judges reason. So judges, in coming to decisions, would apply these same criteria to a new situation in front of them. Because they would also have to ask, is the tenant frequently paying the rent late? And they would put this in the decision. And after that, they would also need to assess, if the answer is yes, if there's a serious prejudice involved because of this. And they put this all in the written decision together with the reasoning of why that was the case. But jurists would have to be the same. Lawyers who want to argue a case would also have to prove that these specific criteria apply or do not apply in their case. And like this, try to convince the judge. And likewise, parties would have to send letters like this to the opposing party. So what if we use this schema that we already have and that we already have the tools to build to generate documents instead? So imagine if a judge would get access to a platform like this and would answer yes and no for different criteria, whether they apply or not. And based on their answer, we could output a template for a legal decision that would already contain the criteria that they need to assess, but leave space for them to explain their reasoning, why they found that criteria to assess, to apply. And in doing so, they could, just by answering this modified version of the JusticeBot, output a legal document that already contains the structure for their decision, and then just have to fill it in. And it gives this structure in a very pedagogical way. And we don't tell the judge what to do here, because the judge already answers yes and no by themselves, depending on what they see applying in a case. And they themselves are also able to modify this or to fill in the reasoning to fill out the decision. Or what about applying this to parties that want to generate claim letters? I know Carl Branting has done a lot of work with self-represented litigants, and one of the important insights is that they often have trouble seeing which facts they need to prove and how to prove them to fulfill their claim and to get to an outcome. And so a system like this, that is again attached to the schema, could ask these questions, but not just ask for an answer, but also allow the party to describe why they think that specific criteria applies, and to attach relevant evidence to this inside the system. So it could explain what is relevant, what they should include, and what kind of evidence might support their claim. And this could then output a document that they could submit to their counterparty or to a court, thereby supporting these self-represented litigants in better making their case and enforcing their rights. But why should we stop there? it is, after all, 2022. Why do we need to rely on documents? What if we took this notion of these different criteria and put them in an online platform, like an ODR platform, as we heard before? So this platform would allow you to, again, describe why you think a criteria applies in your case, and attach relevant evidence, and then upload to a platform and send a link to your opposing party. And they could, for each criteria, see the reasoning around this, why the other party think that applies, and see the evidence, and then immediately in there choose to either admit, yeah, this criteria does apply, to challenge that particular criteria, or to raise a counter argument. And I think this kind of platform could really allow a lot of disputes to be settled in this structured way by the communication between the two parties. But it could also allow, and if that doesn't work, it would highlight to the judge, this is the contentious issue. They agree on these things, we don't need to discuss them anymore, but here are the contentious points and here's the evidence related to those. I know Ken Sato has been doing some work in this direction, and we're looking forward to explore that further inside the JusticeBot project as well. And that's going one way, from the schema to textual documents. But what about going the other way? What about inferring the graph from the decisions? So, as I mentioned before, judges use these steps and apply these criteria to write the legal decisions. So what if we went backwards instead? We could look at the legal decisions, and we could look at the individual paragraphs, and using machine learning perhaps, classify which criteria is assessed in there and what the judge finds. And then we connect it back to the legal decision graph to identify cases that could be relevant to us, and maybe to explain cases to lay users. I know Vern Walker has been doing work in this direction as well. And so here's a prototype that we built using this procedure that allows you to, on the left, input a legal decision, and then classify the different sentences and paragraphs in there in terms of which legal criterion is assessed in there. And all of this is connected to the work we've been doing in building out the decision graph. So as you can see here, the system identified certain phrases and links them to the discussions in the legal decision graph. But in doing this research, we found that there was an issue, and that is that it works quite well for simple cases, where the legal criteria that are assessed for each case are actually the same. But it doesn't work for more complex cases, where the criteria that are raised by a certain case may depend on the arguments that are raised by the parties, or other laws entering into the process, or counter-arguments being raised. And so that's kind of where we see the next research project, the final one that we'll discuss tonight. That is that of having an evolving graph. As before, we had a static graph, where every case is expected to follow the same reasoning. So this doesn't work all the time. And what if we could, and because every case has its own graph, every case has its own reasoning steps that are applied by the judge, leading to a particular outcome. So what if we could annotate these cases in terms of the specific reasoning performed in each case? We could then combine together these different cases and the flexible graphs, the graph in there, to create one big graph that covers all the arguments that are raised in previous cases that we've annotated, into a flexible schema that allows us, that evolves as we find new cases as a reason. And this could allow us to better connect these cases to the text of the legal decisions, and also allow the users to explore and generate arguments. I know Kevin Ashley has been doing a lot of work on generating legal arguments from case law, and this is, I think, an interesting way of doing so. So as you can see, I think there's a bright future ahead. There's many research projects that we're looking forward to do, and that hopefully can increase access to justice and also empower litigants. And we're very much looking forward to share those with you over the coming years. In the meantime, I think there's a cocktail. I'll be very happy to take your questions and discuss with you. Thank you very much.